Welcome back to my deep dive of the law on the TikTok ban. We're talking about all the briefs, we're talking about the applicable law so that when we get to the live oral argument on January 10th, we all know what we're talking about and can listen intelligently. I'm going to go live on January 10th so we can all listen together. For now, let's dive into the government brief. For starters, the government takes the position that the First Amendment isn't implicated at all. The government takes the position that we don't even need to get to intermediate versus strict scrutiny because people have no right to a forum. They have the right to speak, but they don't have a right to choose what platform they're going to use, and that the choice of platform does not implicate the First Amendment. That's an interesting argument, a bold choice. Second of all, the government says even if it does implicate the First Amendment, it doesn't deserve strict scrutiny because it's not content-based. The government argues TikTok ban at most deserves intermediate scrutiny. That's a lower level of scrutiny than strict scrutiny, and so that's what they want. It required an important government interest, not a compelling government interest. And they say that intermediate scrutiny should apply because the TikTok ban is content neutral. Keep in mind that TikTok is saying because you do allow some platforms under the TikTok ban that provide user-generated content for travel and business reviews, that in and of itself makes it not a content neutral regulation, and therefore strict scrutiny should apply. If intermediate scrutiny does apply, it's just an easier barrier for the government to get past, for the court to consider. And the government says that there's a divestiture option, and that option is what makes the law narrowly tailored such that it would survive either strict or intermediate scrutiny. The government goes on to say that there's a long history in the United States of the government regulating foreign and domestic channels of communication. That would be the common carrier doctrine that we talked about a few videos back. One of the funniest parts of the government brief is that they say, and bear with me here, because they wrote it, I'm just repeating it, that disclosure is not a remedy for covert operations. Disclosure is not a remedy for covert operations. That's one of the government's arguments. The government argues that the United States leg of TikTok, which would be TikTok Inc., is just a compelled mouthpiece, that's their words, not mine, for ByteDance Limited, and that ByteDance Limited has no First Amendment right. So they're saying that TikTok Inc., the United States corporation, does not have a First Amendment right because they're controlled by ByteDance Limited, which is a foreign corporation. The government says that the TikTok ban doesn't impact speech at all, actually, because they could still use the same algorithm, but ByteDance Limited just has to give it up to a US company. That's the divestiture option. As to the creators who have also filed suit, the government maintains that their speech has not been impacted at all, that they can say whatever they want, they just have to do it on a different platform. The government compares it to a 1986 case where a bookstore was closed down due to public health reasons. The bookstore sued and said that that impeded their First Amendment right. The government said, you're free to open the bookstore wherever you want. This has nothing to do with the First Amendment. It has to do with public health. The government also maintains that what they call the manipulation of data, which is also known as content curation in the other briefs, is not protected speech. And that it is especially not protected speech because that content manipulation or content curation, depending on who you are, is being done by what they call a foreign adversary, which is a company that has ties to China. The government brief spends a long time talking about national security, basically saying there is a national security issue here. Trust us, we can't show you the information, but it really is there. However, they also admit that a lot of it is speculative. The government says that it's part of China's long-term strategy, which is to create widely used applications that can track users and track data and eventually manipulate the minds of Americans. They may not be doing it right now. The government admits that they may not be doing it right now, but they maintain that it is part of a very long-term game that China is playing to have the ability to manipulate Americans in the future. The government maintains that there is a very real threat that the People's Republic of China is really just using TikTok, its algorithm, and its data for the future purpose of espionage, blackmail, and hacking. The government says that ByteDance did not deny the allegations that were in the super secret filing that they gave to the lower court. And ByteDance says they couldn't deny the allegations because they couldn't see them because they were super secret. But the government still points out that ByteDance did not deny those super secret allegations that they could not see. Finally, the government says that Congress has a long-standing history of regulating foreign investment in the United States. They include radio licenses, dam building, nuclear facilities, undersea cables, air carriers, and communication lines of other examples where the United States government has regulated foreign investment and foreign companies in the United States. Follow along for more. We still have more to cover.